We submit the judge of compensation claims erred when she found she did not have jurisdiction over claimant's September 7th, 2018 petition for benefits, seeking an adjudication of PTD benefits from August 21st, 2018 to the present and continuing. Now, the statute as far as when you can file a petition for benefits is real clear. A claimant can file a PFB for any benefit that is ripe, due, and owing, and they can also file a claim for past benefits and continuing benefits.
Mr. McCabe, I want to stop you there and get some clarification on your positions. Is it true that your argument is that this order should not have been entered at least short of an evidentiary hearing because there was a concession by the employer carrier that taxable costs were going to be paid, which may result in entitlement to an attorney's fee? Additionally, at hearing and on appeal, it's your position that although they will or are paying PTD, it might not have been paid timely, or there may have been a 4 to 6 week gap. It might have been a delay, penalties may be due, etc., and that because of those issues, an evidentiary hearing must be conducted, and the petition. So there are continued disputes. So there is jurisdiction.
Well, the main continuing dispute is they're not willing to stipulate that the claimant is permanently totally disabled. They put in their response of October 4th that
I
the
think
claimant...
Judge Thomas just asked you a very friendly question.
Say again, I'm
and
sorry?
I think I'm looking to your brief now. And did you raise the argument that you should have been entitled to a hearing on these other issues?
Well, no, I didn't raise an issue that there should be a hearing on the other issues. Our position is that when they don't stipulate...
Well, and I think that's the distinction I'm trying to make. To me, it's a very different argument for you to come up and say, I dispute nothing. My client has been paid everything and paid everything timely. I want an order that adjudicates my client PTD, even though all benefits have been paid, were paid timely, I'm not due a fee. Versus here, as I read the record, you may be making that argument, but in this case, you're also making the argument, we have issues in dispute. We're not conceding the benefits were paid fully or timely, and that we're owed a fee. So this is not a clean slate type case where you're coming in and saying, everything has been paid timely to date. I merely want an adjudication and an order that they are paying PT.
Well, the way I'm arguing and the way I'm looking at it is, first of all, let me back up a little bit. There's no question that this judge of compensation claims had jurisdiction when this petition for benefits was filed.
No question.
No question. So they file a response on October 4th saying that they are going to accept the claimant as permanently totally disabled. Now, what statute or rule divests the judge of compensation claims of jurisdiction over the petition when they come along and say we're going to accept the claim for PTD?
Well, I mean, of course, all of us know these cases that talk about the self-executing nature of the system. If I accepted your argument, then in every workers' comp case in which the benefits were resolved post-filing of a petition, especially if paid timely, would result in your demand for an order. And what's the purpose of that? Other than in a PT case, you want to enjoy the modification standard as opposed to being able to voluntarily suspend the benefits.
Well, when they don't agree to enter into a stipulation, they're not accepting the claim in full. They're not accepting the and continuing part of the petition for benefits.
But what about the cases that say a judge of compensation claims cannot award benefits to the future and continuing because it's a continued analysis of MCC? That would be improper.
There's a permanent total disability case. I didn't cite it, but I will file a supplemental thing that says the judge can order and continuing for when a claimant files a petition for benefits for permanent total disability benefits.
Yeah. I mean, I personally, I think you have a very viable argument that the dismissal should not have occurred here, but personally I believe the distinction in this case is the fact that you have raised the argument, we're not saying all the benefits have been paid, so there is a dispute. There could have been a 6-month gap. We don't know. An evidentiary hearing is necessary, which is very different from saying I concede all paid, I just want adjudicated the order.
Well, the basis of the judge's finding that she lacked jurisdiction was because the employer carrier administratively accepted the claim as PTD. But again, that doesn't accept the and continuing part, and permanent total disability means permanent. It doesn't mean, well, we'll pay benefits for a little while, and, if we decide we don't want to pay them anymore, we won't. And that's, this would create a great defense for employer carriers, actually, if you think about it. Anytime a claimant files a claim for PTD, even though they're past due when the claimant files a petition and the judge's jurisdiction, which is what happened here, and which I submit distinguishes this case from the Sperry case the judge relied on and everything else where there was no interruption in benefits. All the employer carrier has to do is say, you know what, we're going to accept that claim for PTD, file a motion to dismiss the petition, which the judge will grant if this case is upheld, and then after it's dismissed, they just scratch their head and say, changed our mind, we're not going to pay any PTD benefits. We decide we don't want to.
Right, and I understand that, but on the other hand, what you're asking would be, in a case where pre-hearing, the attorneys get together and say, we'll resolve these benefits. So we've resolved the issues, we don't need to go to a merits hearing, we'll enter into a straight stipulation. Is it your position that entering into a straight stipulation and an order approving the party stipulation equates to an adjudication of PT such that 44028 would need to be utilized as a modification?
Absolutely, but they won't stipulate to it. They, in fact, and my position is supported by,
But are those benefits due and owing?
beg your
The
pardon?
potential future benefits that you're talking about, are they due and owing at this time?
Well, no, but the statute specifically states that when you file a petition for benefits, you can ask for benefits, it's 440-192-3. It says the claim for past benefits and continuing benefits.
Yeah,
That's what the statute says you can ask for.
But that's procedural, correct? So that you will be able to get benefits from the filing up through the date of the merits hearing. That's for practical purposes.
But Judge, there's a case from this court, like I say, I'll file a supplemental authority when I get back, but it says the judge can award future PTD benefits and continuing. These are permanent benefits. They're not benefits that we'll pay them for a while as long as we feel like it.
Well, IBs are permanent benefits, but you can deduct earnings.
Well, sure
So-
you can, but you can't just decide you're not going to pay them. I mean, what's the point of filing a petition then? Every time a claimant files a petition for benefits, and keep in mind, this petition was filed when benefits were due and owing. The judge had jurisdiction. How in the world does a judge lose jurisdiction simply because they come along and say, we'll pay these benefits? If that's the case, it's a wonderful defense for employer carriers to use it every time, get the case dismissed, then stop paying the claimant. Then the claimant has to turn around and file another petition for benefits. They could go through the same thing over and over. Meanwhile, here's a claimant's got bills to pay, doesn't know whether he's going to get the check the next day or not. In fact, that's one of the other things in the statute I cited in my brief, 44024, the whole purpose of that is for a rapid adjudication of claims and also to eliminate any uncertainty to the claimant as to what benefits he's going to be entitled to. There's no other area of the law in civil practice if an employer carrier comes in and agrees that the plaintiff's entitled to what they're asking. I cited one of those cases. The judge enters an order, final judgment for the plaintiff. Why would workers' comp be any different?
Well, because
And until they agree
workers' comp
to
is segmentalized, and there's a recognition that your physical and/or mental condition may be ever-changing, and quite frankly, probably benefits the claimant more so than the employer carrier.
I don't see how, and that's the purpose of a petition for modification. If a claimant's condition does change, then they can come along and file their petition for modification. But the way it is now, they can just unilaterally say, claimant, you're not entitled, we're not paying you anything more for a while, we just don't feel like it.
Right, but, and I think your argument is much more palatable to me and perhaps my panel members, with the distinction here that you are not conceding that all benefits have been paid and paid timely.
Well, I'm not conceding that because I don't know.
Well, you argued that the benefits were not paid timely.
They weren't
We
paid
don't know,
timely.
and that was, and I specifically looked back to the hearing and your briefs. It was preserved at hearing. It was argued in your briefs that we are not conceding that the benefits were paid timely. In fact, there's a 4 to 6 month gap, 6 week gap.
Well, that's true. The petition for the PTD, they didn't even accept it until about 6 weeks after the claimant reached MMI. So they clearly weren't paid timely. That's true. Absolutely. But I get back to the point where if the claimant, and that's the way the cases seem to me, all the cases too, incidentally, that dealt with this issue are very old cases. But the cases seem to hold that if there was an interruption in the payment of benefits, which there was in this case, claimant wasn't getting any benefits when he filed his petition for benefits on September 7th, then the judge can adjudicate the claim for PTD benefits. And the cases where it holds that the judge can't adjudicate the claim for PTD benefits is where the carrier's already been paying benefits when the claim was filed.
And after an evidentiary hearing where the facts were developed.
Yes, but anyway, I guess I'll reserve the rest of my time for rebuttal.
Okay.
Thank you.
May it please the court. My name is Karen Ferguson, and I represent the Appalese Southeast Personnel Leasing and Packard Claims Administration. The judge of compensation claims did not err when she ruled that she lacked jurisdiction over the petition for benefits filed on September 7, 2018, seeking permanent total disability benefits and supplemental benefits because my clients voluntarily and administratively accepted appellant as PTD, and they began paying the benefits.
And when you say you voluntarily accepted, I noticed, and of course, we have a very limited record here. There was no hearing. There's an appendix to the briefs which have some pleadings attached. And looking at that appendix, there is reference in the pretrial to the filing of notices of action change, although there aren't copies of the notices of action change. So when you say my client voluntarily accepted the claimant as PT, you made that statement on the response to the petition for benefits. There's no evidence, at least in the record, that I could find, and correct me if I'm wrong, were notices of action change filed administratively accepting the claimant as PT and showing that the correct benefits were paid, and if untimely, penalties and interest, and payment was made. Case law establishes both of those two acts to be required to timely administratively accept a PT claim. How would the judge have known whether that occurred, and what's in the record to substantiate that?
Well, Your Honor, I would point you to the record where the carrier actually filed the payout ledger. And that shows, although a bit confusing, it does show that there were benefits being paid, not only permanent total disability and supplemental, but actually on the date that the petition was filed, September 7, 2018, he was also receiving impairment benefits.
Right, I saw that, and there's about a 6-week gap. The PT and supplemental benefit payments don't start till October. I'm assuming, based on your response to the petition, that's because he was receiving wages of some kind, because your defense was less wages received. So even looking at the payout ledger, if the judge had been able to look at that to see were benefits paid timely, that in and of itself shows there was a non-payment, at least, of administrative labeled PT benefits during that time. So, and then there's also payments and then deductions for the same amount. So the payout ledger wouldn't check that box either, would it?
Yes, Your Honor, it would, because obviously I'm a little more fluent in the payout ledger because I work for this client. But if you look at the payout ledger itself, the permanent total disability benefits were reclassified and paid based upon the impairment benefits. So in actuality, although they were called something different at the time they were paid, once reclassified, they became permanent total disability. And therefore, that shows that the payments were made actually ahead of time. It was only a matter of reclassifying them to permanent
Right. Well,
total.
I guess that's kind of my point. We have you here to explain that to us, obviously. I can look at a payout ledger. I did it for years. But in this case, with no evidentiary hearing and no argument, no testimony from you or your client as to what exactly those entries were, why would the judge be able to say there's no dispute here with the claimant's attorney saying we're not conceding all benefits have been paid? Why does that not serve as a basis for a dispute, equaling continued jurisdiction?
I would point to the record where the actual arguments did take place in front of the judge of compensation claims. There was a hearing on this issue. In fact, The lower court actually asked for a hearing because it was an issue of whether to dismiss this petition. At no time during that argument did appellant's counsel, actually the lower court counsel, say, wait a minute, we dispute that these are timely, we dispute penalties and interest. The entirety of that argument was we want an adjudication or a stipulation so that they are forced to seek modification and that my client can feel that there's certainty in his life. Well, what about the certainty for the employer carrier? They picked someone up as permanently and totally disabled that was working at the time, that was receiving impairment benefits to avoid litigation. And here we are. So there should be certainty for both sides. And that's what the intent of the legislature says in 440.014, where we should have a self-executing system. When you ask, you shall receive. And that's what my client did here. But yet I'm standing in front of you making this argument. My client should have the same certainty that once they pay those benefits, they should not face additional litigation. And also in the intent of the statute, it says that it should be at the least expense of the employer carrier, or at least reasonable. It shouldn't be an economic burden. But yet I'm standing in front of you arguing this today.
Okay, I understand the pure issue. And I'm kind of being diverted here, but I understand the pure issue that you're saying they're not entitled to determination of what goes on in the future and future benefits. But as I understand, and she's far more experienced than I am, what Judge Thomas is asking here is if there's a question of whether all benefits had actually been paid, if there's a question of any cost were still out there, anything from the past that may not have been made up, would the JCC have jurisdiction?
If that was something that was raised by counsel to say, we dispute the amount that they had paid, here's what we believe the amount should have been, here is our proof of that amount, we would like to have the judge adjudicate whether or not they were paid correctly. That was not what was raised in the lower court. So to find jurisdiction where it doesn't belong or where it was never actually existed is to put in front of the court something that would be self-executing and making it judge adjudicating. If we're supposed to give the benefits to the injured workers that they ask for, and we do so, then that should be the end of the inquiry. It should be the end of the litigation. But there was nothing raised in the lower court that said, you paid wrong, I am owed money.
Well, I think specifically what was argued, and I went back and specifically looked for this, there were 2 hearings. The final order that we're here on came out of a motion for a hearing. On both of those hearings, I really looked at the record to see was this preserved, and the argument was raised, although secondarily, first argument was I purely want an adjudication, I want an order, but secondly, the claimant's attorney argued that, the judge, you can't dismiss this, you don't even know the facts. There's no facts established. We're not conceding the benefits were paid. We don't think there's a 6-week gap. We're not sure what's been paid, when it was paid, if it was paid timely. So the argument was, in fact, raised in that regard. Would you concede that?
I would not concede that that was raised properly, because what was in front of the judge was really whether or not she could adjudicate permanent total disability on this ongoing, continuing basis. So for the judge to have heard, wait, we're not conceding to anything, it wasn't accurate. She had in front of her the pretrial stipulation. She had in front of her the payout ledger. She knew that the employer carer's position was that we are paying, that we are administratively accepting him. The whole crux of the argument in that hearing was, we want this adjudication. We want to force them into having to seek a modification. And what that would end up being is claimants who are getting what they asked for, standing in line with claimants who are not getting what they asked for. And then you're going to clog the docket with everyone wanting an order, even though they have in their hands the benefits that they were entitled to. Furthermore, if a modification is required, then my client would have to pay permanent total disability benefits until they could seek that modification. If they are correct and he was not entitled to those benefits, then there's prejudice to my client. They cannot get that money back. They could not seek a 20% offset on something that doesn't exist. And so to ask them to be forced into either a stipulation or an adjudication, it ends up with employer carers being prejudice and paying benefits that injured workers wouldn't be entitled to. So the whole point of the hearing was to make sure that the judge of compensation claims heard the issue, heard the facts, heard the evidence to prove what had already been accepted by the employer carrier. And the reason was they wanted an adjudication. If there's nothing further, thank you for your time.
Okay, Mr. McCabe, I was looking for your brief, which I read about a week ago, and I can't find it among all the paper. The issue you raised on appeal, does that have anything to do with any costs that may be owing, any delinquencies, any thing, or is it purely the issue of whether you're entitled to an adjudication of PTD?
Well, the brief that I argued, I mean, to be perfectly honest, was that we're entitled to an adjudication of PTD. That was the point of the argument. Standing here before you, I wasn't the trial counsel. I cannot honestly say whether benefits were paid timely or not. And so, but if what I don't know.
That was my question. I'm just talking about what you've raised on your issue on appeal.
It's because, and at the basis of the judge's order, she says, continuing litigation to obtain an adjudication of PTD where the E/C has accepted PTD does not accomplish the stated intent of the act to provide timely benefits to the claimant at a reasonable cost to the EC. Well, again, when the petition was filed, the employer carrier had not timely and properly provided permanent total disability benefits, and they never argued that before. You know, I heard her say that they were paying benefits. That was never argued at all before the judge. So the judge of jurisdiction. Now, if they're not willing to stipulate that the claimant is permanently totally disabled and then have an order entering the stipulation so that the claimant has a peace of mind of knowing he's going to get continuing permanent total disability benefits unless they file a petition for modification, that's an empty acceptance. That is not an acceptance of PTD benefits. And I don't see where the judge loses jurisdiction when she already had it. And I think they should either have to enter it, and they're talking about economic burden. All they had to do was stipulate, okay, we accept the claimant, we'll stipulate he's PTD, little stipulation, order signed, case over. So I don't know where they're the ones creating the economic burden by refusing to back up what they claim they're accepting.
Sir, in your brief and the conclusion part of it, you wanted the case remanded back to the JCC for further proceedings consistent therewith. On remand, what are you expecting the JCC to do?
Well, what I would like the JCC to do is, unless they're willing to put their money where their response to the petition for benefits is and stipulate that this claimant is permanently totally disabled, for the judge to then have a hearing on whether the claimant's permanently totally disabled and anything else that goes along with it. Because as it stands right now, the case is dismissed. There's no order finding the claimant PTD. There's no way the claimant can enforce anything if they decide not to pay claimant permanent total disability benefits, except for file another petition for benefits and go through the same thing again when the employer carrier could do the exact same thing again, and then the case gets dismissed again, and the claimant again has no remedy. That just makes no sense to me. It doesn't reduce any economic burden on anybody, and it doesn't comply with the Workers' Compensation Act that wants the quick and efficient delivery of benefits at reasonable costs to anybody. So there's our position, and we appreciate the court
Thank you.
listening to us.
Thank both for excellent oral arguments. Do you want to keep on plowing ahead?